Thank you, Noor. It's an absolute honor to be sharing this stage with this esteemed panelist, and especially with His Lordship Justice Asim Hafiz, and also Justice Jawad Hassan, who's also my teacher in the law school. So my subject is to how we can avoid disputes in the power sector. So first, let me begin with that I am working with NTDC, National Transmission and Dispatch Company. So we have to first understand like what sort of disputes we have in NTDC. It's related to construction, although I've been told in the morning that, you know, I'm representing the whole power sector perhaps to identify their issues, which I can slightly touch upon because I worked with the regulator as well now with the NTDC. So basically we have construction sort of disputes, the major ones. And before coming to this conference, I spoke with our concerned contract department, and I asked them like, you know, what sort of issues we are having with the contractors on a daily basis. And I was amazed to hear that, you know, in their contract documents, they are quite outdated. And, you know, we do follow FEDEC terms and conditions, but, you know, since yesterday I've been hearing about this dispute avoidance and adjudication board concept, which we don't have in our contracts. And I was not surprised to know this because in one of the presentations, it was mentioned that only 7% of people know about this DAB concept. And I believe that, you know, if DAB concept was incorporated in our contracts, I believe the litigation and the arbitrations that we have gone through in the past would not have happened in the first place. Secondly, you know, so the question is what sort of disputes can be avoided? So any disagreement, it basically all matters can be avoided. So dispute basically is any disagreement among the parties. I'm not giving the legal definition, but from the layman's perspective, any difference of opinion, any disagreement from the terms and conditions which the parties have agreed upon, they can have a dispute later on. Now, to understand, like, you know, how the dispute can arise, like, first we need to understand the public sector. What I feel is the problem is that, you know, the contracts that we are executing, they are not well negotiated. I have noticed that most of the time parties don't even know what they have agreed upon, and I totally agree with the Mena's presentation yesterday. Like, you know, it's so much important that, you know, what you're going to implement, you should aware of it first. So the breach will, it's inevitable that, you know, the breach will not happen because you don't know what you have agreed upon. So the first thing is that the contracts need to be well negotiated, the scope is well defined, because what happened in the construction disputes is that we are in a rush and we have so many projects and we're just you know, signing off those contracts, and later on we realize that it doesn't cater our whole requirement. And then we have to amend that scope, and that results is not just a written one-liner amendment, it has a consequence in terms of claims that we receive, and in order to resolve those claims, it takes months and months, which eventually delays the project. So, so I feel like, you know, DAB is the solution, as I can see that, you know, we need to introduce it in our contracts to avoid those disputes. And also, if we include this sort of mechanism, like, so there, I think Shahab Saab in the first panel explained the benefits of DAB, and from the lawyer's perspective, he actually covers all what I wanted to say, because, you know, as an in-house counsel, my approach is that, you know, of course we can't end up litigation. There will always be a party who is aggrieved, but I want to focus more on doing things which can improve the performance of the department in terms of formulating those policies and procedures which the company employees should follow. And unfortunately, the problem in the government sector is that, sometimes the guidelines exist, but nobody is following them because they don't know where they exist. We sign off the contracts and we put it in a shelf where we do not see them during the project life. We only open that document when the dispute arises, and they leave it up to the lawyer to find out a solution for them. As they say that, when the dispute arises, contract is the king. So we need to first put an effort, the efforts we usually put in to resolve the disputes, we should put that effort in negotiating that contract well. We should have a panel of experts from all fields, technical, legal, and commercial, who assist internationally and locally. We should benefit from that. We should not just benefit from the foreign lawyers in, defending us in the arbitration disputes, but rather than we should get their expertise in getting our documents in order. This is something that we need to, in the public sector, have to look for. Second, in the power sector perspective, there is, there should be clear responsibilities of the departments, what they have to do. I feel like, there is quite an interference from other departments. Everybody has clear set of roles and responsibilities under their, if there's a company or it's a statutory body, they have their own role to play. So instead of doing their work, there is so much interference in others' work. Our decisions of the departments are made somewhere else. So obviously, we have to, and we are just sometimes other rubber stamp, like, a decision has been made and we have to endorse it. It's very important that, we should be made part of that process of decision making when the decisions are made for us, and that can avoid many disputes in the future as well. Because in one of I think Sheikh Muhammad Ali has mentioned about the treaties, etc. So even in that contract, if we have referred any quality standards, let's say, or any engineering standards, any treaties that we have signed for. So we have to comply with those terms and conditions, and have to get our, there should be a capacity building of the employees that, it's a legal binding document and we have to comply with. This is something which I feel in the government sector, we are not, we are lacking in that area. It's not everything is there, the laws, rules, and regulation, but it's just the will to basically execute those guidelines, terms and conditions, regulation, etc. Well, briefly, what Justice Zulfikar said, that the regulator surely needs to be regulated, because I think what happens is that as a licensee, I have a contract with the regulator as well, because my terms and conditions are set out in the license. Now, regulator role is not just to penalize the licensee. Their role is first to monitor the license which they have given us, and throughout the process, they have to have, these regulations and the guiding principles, our performance standards, they have to be implemented throughout that process. But what's happening is that we are just being penalized by, huge fines, and, it's like, they wait for that something happens and then they have to penalize us. We do understand that the NEPRA generates revenue through fees and fines under their NEPRA Act, but that doesn't mean that the licensees are just meant to be, to be fined with these, if they have set out the non-compliance standards clearly. So, so obviously our experience is not very pleasant, basically because, what happened is that NEPRA, and I give one example for so we have a fuel cost adjustment hearing every month. So under Section 31 of the NEPRA Act, it says that, if there are any fuel variations in dispatching power from the plants, then they have to follow economic merit order. Now, if that merit order is not followed, then obviously there are deviations from the provision of the grid code that is the Bible for NTDC to as a part and parcel of our license. What happened in the past 5-6 years since 2019? Instead of, let's say if they wanted to penalize us, if there was any non-compliance to it, they had a chapter of investigation, and then they had to show cause us and penalize us accordingly. But they penalized us by withholding amounts from our revenue. Since 2019 until date, it has, the amount has accumulated to 42 billion. Now, we approached, so if the question being asked, like how we are being regulated, well, regulator is regulating us by sending us from one forum to another. If we are in the High Court, because one of the panelists mentioned that there is no member finance in the NEPRA tribunal, now we went to the, in the writ jurisdiction, and the NEPRA has not given a single statement on the merits, but all what they have asked the judge was that, they should be remanded back to the NEPRA tribunal, and they didn't have the jurisdiction. Okay. So these are the issues, like, and for the past 2 years, our tariff petition is pending before for the tribunal. And the last tariff we received was 2022, and still our tariff petition has not been fixed before NEPRA. And the user system charge we have been charging is 235, and now it has gone up to 400, but we are still imposing the tariff of 235. So, these are our challenges with the regulator, but, as I say, the lesson is not learned until something changes, and we need to really, engage all these stakeholders if we really want to improve the power sector. And the most important thing is the governance. We have to put the right people on these positions, and by right people, I mean on merit, not based on political choices. Thank you.